Praise the Lord. Jesus is the way and the truth and the life, and no man cometh unto the Father but through him. Amen. So guys, in this video, I just want to talk a little bit about this situation with the court case that my name is being used in. And the reason I choose to say my name is being used in it, because that's how people who are trying to bring about a nefarious agenda will engage with others. They do so because they want to give the onlooker the impression as though the person who's exposing corruption is the one doing the corruption. Are you following now? So how do we, as the one being accused, expose that the accusation against us is totally unfounded? It's very simple. All we have to do is look at the law. And what I mean by that is, if you're looking at the law, you'll see that members of An Garda Síochána unequivocally, indubitably, it means without a doubt, unambiguously, certainly do not have jurisdiction in civil matters. What we're now seeing in our courts is an absolute violation of common sense. It's a violation of our laws. It's a violation of the jurisdiction with which criminal matters are addressed, with which civil matters are addressed in the absence of members of An Garda Síochána. Now, I have publicly asked members of An Garda Síochána on their beat, just out doing their work, I would just ask them, Guard, do you have jurisdiction in civil matters? Of course, the Guard would be obligated to answer you, because he's a public servant. He has authority and he should be respected and honoured. But he's obligated to inform members of the public. That's part of his job, is to uphold the law. And that also means that he's expected to have an adequate understanding of the law. He's not a lawyer. He's not a barrister at law. It would be unreasonable to expect him to remember everything he ever studied. No more than any of us can do that, or very few of us can remember even most of what we've studied. That's just the nature of human beings. Use it or lose it. You might have heard that term. But the Guard has to retain an adequate understanding of the law, and he has to have an adequate understanding so that he can convey an adequate understanding and edify members of the public who would ask him something as it pertains to the law, and therefore his station, his office, his job, his position. So a Guard never has jurisdiction in civil matters. But what we're actually seeing is a complete corruption of our laws by a legislator who remains to this day unknown. Who is the one who legislated for Section 113, 114, 115 and 117 of the Criminal Justice Act 2006? Who is this person? Who gave him the authority to, on his own, take it upon himself to afford members of An Garda Síochána jurisdiction in civil matters? Who gave this man the authority to completely usurp power over the extant, the existing and current laws as it pertains to jurisdiction? What criminals are involved now in a cabal, a conspiratorial cabal, that think they can, at will, operate outside of their jurisdiction and bring legislature through their office corruptly and against the law so that they can actually pretend that they have jurisdiction in civil matters when they have none. When somebody wants to corrupt a system, they do so first by hiding what they're doing. They bring it in under something else that's not going to have the same attention as if they brought it in under another legislation. I'll give you an example and explain what I mean. These sections first came into play through the Intoxicating Liquor Act. Section 7 specifically, which is another section that's being used in the court case where they're using my name. What they're doing is so unlawful, guys. And they're continuing in it, which is horrid. The adult behaviour warning, which is framed, it's given its definition, its meaning, in section 113 or 114 of the Criminal Justice Act 2006. So check it out. Section 114 of the Criminal Justice Act 2006 and section 113, because they both talk about the adult behaviour warning, which is basically when a member of An Garda Síochána takes a complaint about another member of the public from a member of the public, but the guard it wasn't necessary that the guard was even present. So all he's doing is taking the complaint. He's just writing it down. Now, the difference is he takes it upon himself, based upon what this legislation or this section is telling him he can do. He takes it upon himself and he goes up to the guard station. He prints out adult behaviour warning sheet form, and he brings it down and he takes a complaint. He fills out whatever the complaint was on the form and he signs it. And then he pretends as though this basically complaint that he's taken, that he's now assuming is the case, that is fact. So he's foregone presumption of innocence now. He hasn't presumed that the one being complained about has done anything wrong. He can't assume that. And he hasn't presumed that the one being complained about is innocent, which he must. So if something outside of the criminal jurisdiction is purporting to allow a guard do something that he cannot do inside of a criminal jurisdiction, now they're trying to do unlawful things slyly and corruptly. What I mean by this, a guard only has jurisdiction in criminal matters. But what they're claiming this adult behaviour warning is and can be used as is a cease and desist order. So now somebody has, for example, in my case, I was preaching about anti-abortion and about the gospel and I was answering questions about homosexuality as it pertains to Christianity, and giving verses out of the Bible like Leviticus 18:22, a man shall not lie with a man as with a woman, and Leviticus I won't say, I can't remember the other one at the moment. I think it's 20. No, it's not coming back to my mind. So anyway, they're close together in Leviticus. They're a couple of chapters apart. So 2013 it might be. So what is scriptural verses? What are scriptural verses being spoken in public, addressing a question about homosexuality, now cannot be unlawful by any stretch of the imagination, because a Christian has to have the right to profess and preach their faith, and members of the public have to have the right to ask them about it and listen to their answers. But what they can't do is say, simply because they don't agree with it, that they've been offended or that actually an offence has been committed. So no offence has been committed. So if a guard acknowledges that, he says, you haven't done anything unlawful, I can't arrest you, you haven't done anything unlawful, but you must cease and desist this because I am giving you an adult behaviour warning. Well, we have to assess what that means. What has the guard actually done? Well, all he's actually done is take a complaint off of somebody. So now he's operating on prima facie evidence alone. It's all hearsay. He's only going on what this person has said. So he can't assume that what this person has said is in any way condemning of the other person in any lawful aptitude, because he can't assume that what is being said is true, and he can't assume that what is being presented as offending that complainant is actually equivalent to a breach of the law. So if he can't do that, he can't give you a cease and desist order on the basis of what somebody has said. Why? Well, firstly, this is a civil matter because he hasn't actually established jurisdiction. That's why he's not arresting. So if he hasn't witnessed a crime, he can't tell somebody to cease and desist doing something he can't arrest them for. That would be completely nonsensical and irrational. So if he can't say, I'm arresting you now because you've broken the law, what is he doing there? Somebody might say, well, he's after being called and he might be trying to de-escalate. No. Now he's conspiring with the complainant because he hasn't witnessed anything. He's only gone on what they've said. He's presumed you're guilty because he's gone up to the station, he's got an adult behaviour warning, and now he's given it to you as though it had the power of a cease and desist. Because he's expecting that on the basis of this adult behaviour warning, which is basically a signed complaint, that he hasn't been around to witness any evidence. He's only going on hearsay now. So now he has an adult behaviour warning, which actually isn't a lawful document. It's a nothing. So it's just a piece of paper. He's throwing it around like confetti. He's saying, if you don't stop, I'll give you one of these. Stop what? Am I breaking the law? No, you're not breaking the law. But stop. Because people want you to. Oh. So are you their personal mercenary now? Are you acting as their personal guard? Because you're not allowed to do that. Because you're not allowed to give anybody unfair advantage before the law. Now you're not being impartial anymore. So now you're outside of your jurisdiction, you're not being impartial, and you're not allowing presumption of innocence or innocence until proven guilty. So they're the three fundamentals of your office, and you're not doing any of them. You've said that the person hasn't committed a crime, but now you're telling them that they have to stop doing something for no other reason than somebody doesn't want them to do it because they don't agree with what they're saying. Now you're basically spearheading a mob. You're conspiring with them, and you're using your position as a guard to break the law. Because now you're saying the adult behaviour warning has the power of a cease and desist. But it doesn't, because 3 of the 4 of them have to accumulate before a guard can summons you to a civil court to prosecute you on the basis of hearsay, even though he hasn't witnessed a crime. What's he going to summons me for? What Mary said. The guard's going to summons you on the basis of what Mary said, but the guard is saying and reiterating, repeating, you haven't broken any laws. Well, if I haven't broken any laws, Mary not liking what I'm saying doesn't mean that you can play judge, jury and executioner on the side of the street and tell me if I keep doing what's otherwise perfectly lawful, apart from your disagreement with it or Mary's disagreement with it, which doesn't make it unlawful, you have to allow me to continue doing it. But now you're telling me that I should stop because you've assumed that it's antisocial behaviour. Well, here's the disconnect. Antisocial behaviour has to be criminal behaviour. If it's not criminal, you can't call it antisocial. Why? Because we live in a society that allows people to speak their mind, whether everybody agrees with them or not in the vicinity. So, first of all, a guard has no jurisdiction in civil matters. So he can most certainly never summons you to a civil court to prosecute you because he has no jurisdiction there. Therefore, any section of legislation, of legislature, that purports differently is unconstitutional and a direct affront to the criminal jurisdiction that the guard does actually hold. So the guard will say, well, you haven't broken the law. Well, what are you giving me a cease and desist order for? It hasn't gone through the courts. This doesn't have the power of a cease and desist. Are you telling me that I have to stop doing something that you've basically said is perfectly lawful because you're saying I haven't done anything criminal? Well, it's either criminal or it's okay to do. It can't be both. It can't be criminal and lawful. So if it's not criminal, it's lawful. So you can't tell me that what I'm doing is antisocial if it's lawful. Do you see how la-la land it's gone? How completely disconnected they are from reasonable thinking? Those sections are so unconstitutional that they must be removed. But our High Court is running away from testing them against the Constitution, accepting late appeals to the Court of Appeal. But listen, it gets interesting. The High Court were operating in the criminal jurisdiction. But now they're claiming that the Court of Appeal are operating in a civil jurisdiction. So they're saying started civil, went criminal, continued criminal, went back to civil. You can't address criminal convictions in a civil court. You simply can't. If you're looking to overturn the quashing of criminal convictions, the only place that can ever occur is in a criminal court. So when you actually enter in or apply for a civil appeal, you just failed to actually appeal anything. The judge failed to establish jurisdiction to address what they've appealed. Therefore, currently the Court of Appeal in Tallon versus the DPP and the Attorney General has failed to establish jurisdiction to address the quashing of the criminal convictions. So they have to throw it out. They've no other choice. Now, a third party have, from a humanitarian group, that's the wrong word I've used there now. What are they? I can't think of the name of the group who want to get involved and play advisor to the judge on the day. But if they haven't yet realised either that you can't have a civil appeal of a criminal conviction, then where are their heads? Are they telling me that members of Garda Síochána, the Attorney General, the State of Ireland, the High Court of Ireland, the Court of Appeal, it hasn't dawned on them yet that civil court and criminal court are two different jurisdictions that can't blend? They can't blend, but the devil is working there, and he must go away in Jesus' name. Because criminal court is separate jurisdiction to civil court. You can never use a civil court to overturn the quashing of a criminal conviction. Just like a guard can never get involved in a civil jurisdiction. They're so all over the place right now that they're breaking laws hand over fist. The amount of laws they've broken right now, I've lost count of. And at the Court of Appeal level in our country, they're now pursuing a civil appeal. It's an absolute laughingstock. They're making us look like, I don't know, like a party in a lunatic asylum. Just an open asylum. That's what this country looks like right now. Because it's madness what they're doing. Claiming that guards have jurisdiction in civil matters when guards will tell you themselves, we don't. No, we don't. Well, how can a guard then summon somebody to civil court to prosecute them there? Prosecute somebody in a civil court? You can't do that. Oh yeah. Guards can't pick and choose who they're going to represent. Oh yeah. They can't choose sides in a dispute of a civil sort. Or any sort. Oh yeah. They just have to give evidence. Yeah. And what happens when they weren't there? They can't confirm or deny anything that's been said. It's only hearsay. You can't convict somebody on the basis of hearsay. That's only prima facie evidence. That means evidence of face value. Whilst it's considered evidence because it's been submitted to the court, it's never enough in and of itself to lead to a conviction, but they claim it is. Why, Judge, are you convicting this man? No reasons given. Why? Because if they don't give reasons, they don't have to be held accountable to the reason they give, and then it's less likely that people are going to try and investigate and turn over and disprove their position because they haven't given one, other than this man broke the law. The court found this man behaved antisocially. Why? Okay, that'll be all. Court dismissed. They won't answer anything. But when they've blundered so basically, so fundamentally, in telling guards that they can operate in a civil matter, and then they're at the highest courts and they're still making the same basic blunder where they're saying you can have a civil appeal of a criminal matter, they're making themselves look like a slumber party. That's what they're making themselves look like, because they must be half asleep. You would assume that. At least somebody reasonable would say, how can a judge make such a fundamental blunder unless he's exhausted, tired, and half asleep? And such a fundamental one, like they must be like children, like sleepy children in there. No, it's far worse than that. They know what they're doing is wrong. They know that there's clear distinction between civil jurisdiction and criminal jurisdiction. But they are hell for leather, refusing point blank to admit that they've fundamentally blundered, to the point where they've dug a hole for themselves so big that all they can do now is throw out the case. They have to throw it out. And they have to get back to the testing of the sections 115 and 117, which also calls into question 113 and 114 of the same Act, the Criminal Justice Act 2006, that tells guards you can get involved in civil matters. You can summons people to court to prosecute them on the basis of what somebody said, even though you weren't there to witness anything. It's all based on a complaint you took. And you conspired with other guards, accumulating adult behaviour warnings, even though none of you were there to see the evidence, none of you were there together on the same days. You all conspired together back at the station, even though none of you were actually involved in the same complaints on the same days, collecting the same evidence, and you've no solid irrefutable evidence, and it's all on the basis of hearsay. And now here you are conspiring together with a mob who are conspiring together. And so this is a big conspiratorial mob being spearheaded by guards out of their jurisdiction in a civil court, and they're saying that now they have the power to prosecute somebody in a civil matter in the complete absence of any solid irrefutable evidence. Now they're conspiring with the judge who's conspiring with them out of jurisdiction, claiming he has jurisdiction where he hasn't established it in a civil court, to try and steal somebody's free speech rights from them, telling them they've behaved antisocially because a group of people have disagreed with what they've said, even though what you said wasn't criminal in any way. can't be classified as hate speech, can't be classified as unlawful in any way. Here they are, making a mockery of our systems, saying that guards can get involved in civil jurisdiction where they just can't, because it would forego presumption of innocence, impartiality, everybody being held equally before the law and due process of law. Imagine being able to give a cease and desist order on the basis of what you thought as a guard on the side of the street. You must stop doing what you're doing, even though it's not unlawful, because Mary doesn't like it, okay? I'm pretty sure I don't have to do that. Right, well, you're going to prison for a month because the judge agrees what you're doing is antisocial. Why? He didn't say. Right. Okay, now I'm in prison for a month. Then I got out. They denied me bail. Why? Because I didn't stop preaching the gospel of Jesus Christ. I didn't stop singing hymns about Jesus. Oh, why would you ever have to stop doing that? You don't. Oh. And it says, unless you must comply with the said civil order, unless you have a reason not to, reasonable excuse not to. How about it's my lawful right to preach about Jesus and sing about him? Oh yeah, that would be adequate reason not to comply with the civil order. Yes, but the judge didn't agree, and so he refused me bail, left me in prison for a month, then gave me 7 months in prison as a sentence. Then it got to a circuit court appeal. They adjourned it on the basis that the High Court had submitted that they should test the constitutionality in section 115 and 117. Then I went to the High Court, where they were operating in a criminal jurisdiction. It was a judicial review. That's not a civil matter. They were dealing with criminal convictions. That's a criminal matter. In a High Court, yes. Okay, we're agreed. Then the state lodged a civil appeal of a criminal matter in the Court of Appeal, totally mocking everything that had happened, that is basic and fundamental to Western law all across the Western world, not just in Ireland, but all across the Western world. Why? Presumption of innocence, impartiality, jurisdiction, due process of law, all of the fundaments that protect us against rogue officers and people who would just say anything about us, and people who are operating in government who just want to railroad us in court. Okay, but if they haven't established jurisdiction in a criminal court, they can't hold court. You can't have a civil appeal of a criminal matter. So now I'm being emailed by a third party who want to play advisor to the court on the day. They're saying, please acknowledge that you've been served. I haven't been served, because no jurisdiction has been established by the Court of Appeal, because they're trying to accept an appeal a month and 4 days late without any application for an extension to appeal. The Court of Appeal accepted a civil appeal of a criminal matter a month and 4 days late without any application for an extension to appeal. How can I possibly accept anything from anybody pertaining to that date where they've said there's going to be a court hearing? They haven't established jurisdiction. I'm not going to be aiding and abetting them in that criminality or being a party to it. So they can send me as many emails as they want requiring me to accept that they've served me something. They haven't served me anything, because jurisdiction hasn't been established. You can't have a civil appeal of a criminal matter, and that's what I keep emailing them. They keep emailing me, and then I email them back. Do you realise that the court are trying to have a civil appeal of a criminal matter? Please acknowledge receipt of da da da. They just keep saying the same thing over and over again. They're not addressing the points I've made, and so I've told them they haven't established jurisdiction. So please see that. Please address that issue. No, they just keep asking me, please confirm that you've received this, or we can summons you. Now you're going to try and summons me to a civil appeal of a criminal matter? That's like trying to summons me to a civil court. You can't do either. You don't have jurisdiction. No jurisdiction's been established. I will not aid and abet you. You're using my name unlawfully now in your attempting to establish case law outside of jurisdiction. And you're digging a big hole for yourself. Whose name is that on my hat? Are you going to try and use a man of God as a pawn in your corrupt game? How far do you think that's going to get? But they're so gung-ho that they won't draw back. They refuse to. It's against them. In principle, they never draw back unless they're forced to. Well, now they're forced to, in Jesus' name. Because the God of heaven is the one who establishes all the institutions. He's the one that institutes the powers on the earth. Do you think that God is going to allow them to blur civil and law, criminal jurisdictions? Well, it'll be his will and not mine. But I don't think so. To use his servant as a pawn in that? Hardly. I don't think that's the case. It will be his will and not mine. Do they really think that they can use a man of God as their pawn? Use his name. Use that. See the arrogance of the devil? He even tried to tempt Jesus and told Jesus to bow down to him. That's the type of arrogance you're talking about. Complete abandonment in arrogance and pride. And the devil's far worse than that again. A futile dragon. Manipulating in the detail. And what did they do? Say nothing, like a basic thug. Say nothing. Deny it. Say nothing. He asks you for a reason. Say nothing. They operate the same way. The top of society and the bottom. Thuggish behaviour. Say nothing, saw nothing, do nothing. Keep driving on forward until somebody tells you to stop. And then play dumb and blame somebody else who's sick that day. They're so corrupt. But this is so fundamental to law that a guard on the street on his beat can tell you, no, we've no jurisdiction in civil matters. The commissioner of the police doesn't have a jurisdiction in civil matter. The highest ranking member, he doesn't have jurisdiction in civil matters because guards don't have jurisdiction in civil matters. That'd be like a member of the army trying to prosecute you in a civil court. It's as futile as that. So let the devil be rebuked. You can't have a civil appeal a month and 4 days on the basis of a late application, a month and 4 days late, in a criminal court. Let me repeat, because I was trying to say too many things at the same time. You can't have a civil appeal of a criminal matter in the Court of Appeal. You can only have a civil appeal of a civil matter. You can have a criminal appeal of a criminal matter. A guard can only address a criminal matter. He can only summons you to criminal court. Guards don't have any jurisdiction outside of criminal courts. They don't have any jurisdiction in civil matters. They can never prosecute you, pick and choose who they're going to prosecute or represent in a civil matter. They know this. Why does this legislator, who remains evasive and unknown, think that they can legislate for guards having a position in civil matters? They don't. So the court obviously refused to test the constitutionality of Section 115 and 117, even though it was before them. It was actually scheduled in a court case and they abandoned it. They gave no reason for doing so. Even though the convictions would have been naturally automatically quashed, if they had tested the constitutionality of those sections and found them unconstitutional. So it was most pressing that they do that first. They abandoned it. Then they found the convictions unlawful and quashed them anyway. Now they're claiming that the Court of Appeal, higher court, ranking court, have accepted a civil appeal of a criminal matter. They're all over the place. It's like they're all on acid or something. They've gone mad. Guards have no jurisdiction in civil matters. You can't accept an appeal a month and 4 days late. There has to be an application for an extension to appeal. Even that has a time limit. But yet they did accept it. in the Court of Appeal for a civil appeal of a criminal matter. It's preposterous. They can't address in a civil jurisdiction criminal convictions. So they haven't established jurisdiction, but they want me to be a party to it and show up on the day on the hearing. They think they can summons me. They think that they can serve me documents, notice of motion, for a civil appeal of a criminal matter. No such thing. I'm not going to aid and abet them in this. I have no part in it. It's totally unlawful at the highest level of our court system. Civil matters in a criminal court. Addressing criminal matters in a civil court. Guards in a civil court. They're all over the place. It's like somebody spiked their drink. They're gone mad. Jesus is Lord. Let the Lord bring peace and order. Because they can't do it.